The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance.
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say this was a very difficult decision to make. I have in front of me allegations of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain, is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion. It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoints from law enforcement officers, as well as other things, which it's not an exhaustive list, But I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third persons. The court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone amendment, and the amendment to count one may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law in its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remains: the defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed, and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial, as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser included, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law and the entire criminal justice system. The defendant was not only on probation at the time of these actions, but was also being monitored by the law enforcement and by probation with certain conditions and mandates. The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason, no matter the reason or the excuse. Bears, squirrels, protection from burglars, or zombies makes no difference. The defendant is a convicted felon and has no legal right to possess a firearm for life. He intentionally disregarded that prohibition and spat at the legal system, believing he was above the law and could do what he wanted as he wanted. What happened that day was one of the most serious crimes that could have happened in a situation like this. The only worse outcome would be if the victim had died. Even though the defendant accepts the offered plea deal and admits to guilt, or would admit to guilt, thus eliminating the need for a trial, that is not a decisive factor. The impact on the victim must be viewed as well. The victim in this case is not opposed to a trial. Even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim, it is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges rather than the court accepting the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. The state and the defense argue that there is inadequate evidence to prove and support count one as charged. The court is not making that determination. The jury is an impartial and unbiased decision-making body. The jury will determine the credibility and the believability of the facts, testimony, and evidence presented at trial. The state could request of the court permission to amend and file an amended information. If the matter does proceed to trial, should the jury find the defendant not guilty on count one, attempted first-degree intentional homicide as charged, without a lesser included offense presented, the victim must abide by and accept the decision of the jury. Even count one, not part of the equation, there remains 7 additional counts in the information. There is a possibility that the jury could find the defendant guilty beyond a reasonable doubt with the remaining 7 counts, thus increasing the potential sentence exposure to the defendant, leaving the court with a sentence determination. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not received. Mr. Schmidt.
I understand. Thank you.
Mr. Harrington.
Judge, I would request that the court reporter prepare a transcript to expedite the transcript. The court, and also because this is dean appointment, request that the court authorize me to inquire of appellate counsel for the purposes of interlocutory appeal.
You must do that in writing, and the transcript's going to say pretty much a lot of what is in my written decision, but you'll get both.
I need both. I need it expedited because the time for the request for interlocutory appeal is 10 days, if I recall correctly.
20.
10, 20, doesn't matter. It's a holiday week next week. And then one final question, as it relates to interlocutory appeal and the evaluation of that as an option to the defendant. Will the court permit second-degree reckless endangering safety with the firearm to be a lesser included offense to the count one as alleged in the information? It goes to a jury. Do we get to use that as a lesser included offense? Kind of a premature question, but
It could be a premature question, but I may not have been as specific in my statement to the attorneys. The attorneys know the facts better than this court. Attorneys know the facts more in and out than this court. And whether or not, as it relates to intentional homicide, even as an attempt, whether or not the facts would be applicable or they would be able to meet each of the elements of that crime. As I stated, the attorneys have reviewed this. The attorneys have determined that second-degree reckless with the modifier may be a more appropriate charge. The state can always amend the information or can be a part of a different plea agreement, plea deal with other things included. Count 1 was not the issue for the court.
that raises another issue that I may have to consider for an appeal, but I understand. Thank you, Judge.
We're totally fine going through with the trial with all 7 counts or all 9 counts as they've been charged. And the court is simply saying the jury, the unbiased decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9, they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 through 9.
When's our next status hearing, Judge?
Whenever we set it, we're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
I agree. That's what the law says, Judge.
What are you looking at? How far out?
Do you want to revisit this 17, 18 of July? You and I will revisit before then, but
Why don't we talk after this hearing? I think you might have heard things from Judge that she didn't say.
And you're going to get my written decision right here that says everything that I said.
sure.
Everything I said. All right. So I don't have the ability to do the 17th or the 18th, but
The next week of the 21st.
1:30 on July 17th. And if you're requesting a transcript, it must be in writing to the court reporter.
I'll send you an email.
All right. Anything further?
Not for me.
Mr. Harrington?
Thank you.
Thank you. We are adjourned.